Okay, so I usually just start the session by introducing the Facebook group, just so people know who's hosting tonight and where you can meet us. We're all in the Parental Alienation Canada Facebook group. Oh, I gotta share my screen. Whoops, sorry. All right, so sharing screen. Yeah, so this is our group. It's growing pretty quick compared to some groups. I think we're like pretty dynamic. So I think there's a lot of good people in here and really great peer support. I'm really proud of everyone coming together and helping other parents out. And like I see a lot of the members helping each other out with problems and inviting people to talk about chats that they don't want to talk on the page. So I'm really proud of everybody. You guys are doing a great job. Thank you so much for helping each other. And I think one thing that sets our group apart is we do moderate, like we have team of moderators. And so I think we have a lot of common sense rules, like no spam and advertisements, for example. So yeah, I think that sets us apart. And we try to have events about once a month just to have information, dynamic information coming up when we have these discussions that we need to have. So I just booked an event for October with Dr. Edward Crook. I talked to him today and he's confirmed for October. So I'm pretty excited about that. All right, so that is that. And I'm just going to jump right in with the questions. So the format we're gonna have, I'm just gonna ask some questions for Brian that I already asked him if I may ask him, so he has time to prepare. And then we're gonna open it up for Q&A. So if you have any questions, you can put them in the chat so you don't forget them, or you can wait till it's time to ask questions, basically. But so just bear with us as we get through the questions, and for that I have for him, and then we'll get to your questions. All right. So Brian, your history speaks for itself, but and your career. But I just wanted to ask if you could tell us a little bit about your background in parental alienation. I know you work in family law, and I think you work in other forms of law too. But like, what specifically drives your interest in parental alienation?
Well, I was trained as a business lawyer. Everything from, could we have everybody mute, please? I was doing everything from entrepreneurial work right up to the types of public company transactions that you would see in the National Post and the Globe.
Mhm.
And in 2005, I faced personally a parental alienation situation. Had no idea about it, wasn't even aware of the term. It took me about 6 months till I stumbled on the term. And obviously there was a lot less known about it at the time. But I, being a quick study and having a lot of interest in a lot of different areas, I'd say within about 1.5 years, I had my own situation solved. Then people started referring others to me just to talk to them, give them advice, because I know a lot of people, and I was just happy to share what I've learned and how I was able to solve my own situation. And then people started asking for me to become their family lawyer. And even though I was learning about the family law system on my own case, which went on for more than a decade, not on the child side, but very complicated financial matters, I didn't quite feel ready. So I partnered with my own family lawyer at first. And then as I got more comfortable, I started to take the cases on just individually. Probably the turning point for me was in 2009, when somebody who I'd met in passing, an alienated dad, had spent 3 years putting together a huge 3-day conference that took place at the Metro Toronto Convention Center, 3 full days and evenings. And most of the North American experts were up speaking. And I was one of 2 lawyers speaking, and my presentation focused on practical strategy to survive one of these cases. And it went very, very well. There was electronic media, print media, So I got a lot of press, and I never looked back after that. And rapidly, the portfolio of work that I was doing shifted from business law consultations to pure family law. And from there, it was just a continuation of speaking, not only locally, but internationally, joining various advocacy groups. So that's how I learned this world from the inside out. And then with more than a decade of experience helping others now, you become a pretty quick study if you're doing this this unfortunate, as my partner and I commiserate with each other, very unfortunate line of work, 7/24, 365. You continue to learn and learn. And now I find myself called on by members of the family law community all over the world for consultation mandates, where I'm advising a client in the States who has their own local lawyer, or Europe, on how to conduct one of these cases. So that's very gratifying because I get to help more kids with limited bandwidth. Over the years, my firm has grown. Proud to say that my son, who was alienated for a short period of time, has joined me in my law practice. And my daughter, who was headed toward a business and finance career, switched to clinical psychology, and she's now a fully qualified practicing clinical psychologist. And I think that her experience in going through all of this was obviously influential in that regard. So it's really been an eye-opener. I've met some really interesting people along the way, and there's a whole side of life that in the cloistered world of big downtown international law firms you just don't see. It's very rarefied air, and everything from therapists to how the court system works, how the political system works. I was an invited speaker at the House of Commons Committee studying Bill C-78, Canada's recent Divorce Act amendments after 30 years. And then they had me back to speak to the Senate committee as well. And that was on the topic of equal shared parenting, which is another passion of mine, having seen the divorce wars and just seen it not being an evidence-based, sensical practice, and comparing what I'm seeing to the many other areas of law, tax law, bankruptcy law, corporate finance, business law, where things just make a lot more sense. There's rules, there's much more predictability. Family law is quite dysfunctional, and really to no productive end. It seems they impose the commercial litigation model on a social dynamic or psychological dynamic that doesn't fit. And equal shared parenting will not end parental alienation, but it will go a long way toward really doing two things. One, making it a lot harder to get any benefit out of alienation. And two, removing from the system the non-alienation cases that are cluttering the system. People fighting over, is it 50-50 or 60-40 or 65-35? And the public shouldn't be funding that, the desire of one parent to be the dominant parent.
I think that kind of dovetails into the next question I have for you, actually.
Sure.
And a lot of people have mentioned to me about your empathy and your down-to-earthness, which is quite frankly difficult to find in a lot of the family lawyers. And I think that's what sets you apart. And a lot of people appreciate the down-to-earthness, and you're not theoretical or up, like I said, like in this framework that doesn't seem to make a lot of sense. You're pretty much down to earth with everybody else. So I think a lot of people appreciate that about you.
Well, thank you. Thank you for that. I mean, you have to adjust to the forum. You know, there's a different persona when I'm advocating in Ottawa. There's a different persona when I'm advocating in court. There's a different persona when I'm deposing the other side of a case.
Yes.
You have, you know, you have to kind of pull it out. But I do have a fundamental empathy for targeted parents, having been a targeted parent myself. It's a huge advantage in
Yes.
terms of connecting with the client and preserving the client's dignity and understanding where the client's coming from, understanding the reassurance that's required to help them get through it. And you know, it's quite gratifying, particularly when you're successful. This is the gift that just keeps giving.
You mentioned the framework, and I just wanted to ask you about
Sure.
that because one of the questions I had for you was about that Meyer study. And so you mentioned a framework that doesn't make much sense. And maybe some, you know, lobby groups or ideologies are maybe driving this framework. And so the Meyer study, it claims that abusive parents use PA as a defense, and this has been debunked. And all the problems with the Meyer study, like as far as the academic and the peer-reviewed scholarship show, like there's a lot of problems with the Meyer study. But if I Google estrangement, the first thing I see, is that, you know, estrangement, which is like legitimate rejection of a parent due to abuse, but then in the same page, I see, if I Google estrangement, it says that these parents use PA as a defense. So it seems that, you know, this framework or whoever's pushing this lobby seems to, it's everywhere. It's like ubiquitous, basically, this narrative that the Meyer study is promoting. So can you comment on the Meyer study and its pervasiveness?
Sure. So first, I think it's been given way more press than it deserves. Yes, it's inherently flawed. And if you take a look at Meyer's other writings, they all betray the same bias and positioning that is exhibited in this one. And frankly, it's very unpersuasive. And in the court system, it's really of no import at all. So every time that the various groups with which Meyer is associated attempt to advance their narrative into the court system, and they usually do it by what's called amicus briefs, so friend of the court briefs, and they try and intervene in appeals and other high-level or high-profile cases and advance their thesis that PA is simply an unscientific construct, and they attack Dr. Gardner, etc. And there's answers for all of this. Those amicus briefs are never successful. And what they do is they get large firms, you know, firms of at least national stature in the United States, to do some pro bono work for them and put in an amicus brief into the court case. And they're just so unpersuasive. They're so easily handled. The jurisprudence about what PA is so robust now that the horse has left the barn, the ship has sailed, whatever piece of rhetoric you want to use. It's too little, too late. In the legal world, truth has prevailed and we've won. And the ultimate statement is a case that I actually was consulting on and helping another local Toronto lawyer here. It goes by the acronym D versus T. And there, the court held that parental alienation is so settled that the court took judicial notice of it, meaning it doesn't have to be proved. It's as obvious as the sky is blue. It's beyond debate. And also that it's extremely harmful to children. The court took judicial notice. So that is a sign like we have landed. I recently won my third Court of Appeal case in a row defending a reversal of custody. And if you read the facility with which the court just deals with the phrase parental alienation, it's the same thing. We all know what it means. It's beyond debate. It's not a good thing. Trial judge found parental alienation. So if there's a lot of people who are worried about the Myers study because you see it in social media, et cetera, but
It's
in the
also in
real
our group, like like we have people that I think misrepresent themselves to enter the group, and then they will, you know, propagate this narrative, and I don't think they're actually like advocates for PA awareness. I think they work for, I don't know, some lobby group or something, or they've got some
Okay.
other agenda, and they are like, you know, infiltrating our groups and basically arguing and perpetuating the myths. And
So
they're just
really all you have to say is it's been thoroughly debunked. You know, there's a lot of gaslighting going on there, and you just have to say it's thoroughly debunked. The courts are consistent. We all know what it means. If anybody gets into a situation where they're actually looking for some really good sequential analytical pushback, just reach out to me and I'll help you give a devastating pushback on it. So we have some wonderful worldwide experts that are taking on the Joan Myers of the world in the social science world, and in the legal world we have not enough lawyers well versed in this, but those of us who are speaking and teaching and writing and winning cases, and the weight of that because of the power of precedence is literally like a ball rolling down a hill now.
okay.
That's where we're at.
My next question relates to that then, because LEAF petitioned the UN recently to remove PA from the index, and they succeeded. And they were, I'm pretty sure they were citing the Myers study. And so I have my own opinions about the UN. I probably shouldn't share here, but yeah. So how could, like, you know, that they are an international organization that used to recognize PA, and they've been convinced by the Myers study to remove it from the index. So it, like, that's what I mean about it seems ubiquitous.
Yeah, well, let me explain that one.
Okay.
Because so it's the World Health Organization publishes ICD-11, and the debate there was simply to see if PA could be included not as a health code classification. So ICD-11 is the consensus worldwide index of medical and psychological disorders, and they do have a, you know, chapter 24 is basically factors influencing health status or contact with health services. And it's within chapter 24 that there's some room to look at, you know, family relational matters. So the actual
a mental health issue, especially in children,
yes,
severe mental health problem and a long-lasting one.
Okay, so no one's debating that. The question is, how's the World Health Organization going to deal with this dynamic? Okay, there are a lot of childhood traumas, and many of you would be familiar with the concept of adverse child experiences, very, very broad. Mm-hmm. Those of us interested in this area are interested in quite a pervasive dynamic. You have only to look at my good friend, Dr. Jen Harmon's prevalence studies and the prevalence studies of Klawar and Rivlin, who did the 1,000 family study for the American Bar Association. and their book's called Children Held Hostage, currently in its second edition. So we know it's serious. We know it's very broad-based. Up to a third of adults have had direct or indirect exposure to this. And we know it's a major social ill and a drag on society's resources. So it's not to be minimized. Whether or not you find the term in ICD-11 does not detract from PA's legitimacy or the way courts should respond to it. Courts have been responding either effectively or ineffectively, or effectively but too late, long before there was even a proposal to get it into ICD-11. So it's important to understand the background. So in the context of the other book, the big blue book, the DSM-5, which is the Bible of the mental health community, with its coding, as many of you know, my good friend and colleague, Professor Bernet, led a whole team making a formal presentation that PA be recognized in ICD-11, in DSM-5. And while that was not successful, there are about 4 or 5 DSM-5 codes that, without using the term, clearly refer to the type of situation that we find in these families. So in that sense, the battle is won. But it's important to look at this whole issue of ICD-11 and DSM-5 in the following way. There was a condition first described after the First World War called shell shock. And anybody exposed to assisting those who put their lives on the line for us knew what shell shock was, and treatments were starting to be developed, etc. And it only got its formal designation of post-traumatic stress disorder and entry into the DSM many decades after it was first identified and studied. So is the fact that for all those years, shell shock, under any name, was not a recognized psychological disorder, did it detract from its legitimacy? Of course not. And are there certain mental health problems that were characterized one way and then reconceptualized and suddenly characterized another way? Does that detract from the underlying seriousness of the matter? No, it doesn't. So it's important to bear all this in mind. And now let me restate what actually happened with ICD-11 so that you'll see it was never in the first place. And this was not going to give it any real legitimacy because, as I said, it's focused on health disorders. And the only place that you could find a reference would be in Chapter 24, Factors Influencing Health Status or Contact with Health Services.
How are you going to cook the pork chops?
Sorry, could somebody go on mute because we're hearing something about dinner? Okay, all right. So there's an entry in the ICD-11 for caregiver-child relationship problem. PA was going to simply be an example of that. So simply an index term. So it's going to, when you're explaining what is meant by a caregiver-child relationship problem, one of the examples would be parental alienation. So that's a truism. There's certainly a caregiver-child relationship problem there.
Mm-hmm.
And this was just going to be an example of that, and therefore it would be what's called an index term because all terms used in the actual coding or examples of the coding get indexed.
Okay.
And incorporation of a term that way never indicated the World Health Organization endorsement or any sort of formal recognition. It was only an acknowledgement. It's a term that you may run into in healthcare settings and therefore may need to be classified. And the particular committee, the Medical and Scientific Advisory Committee of the World Health Organization, had studied the issue, and in September 2019 said that it's it in that context. So that, of course, in parallel with that, a group of PA deniers from around the world were working on this collective memo of concern. So this is not Meyer, this is not Leaf, it's a whole bunch of them from around the world, although some of it was spearheaded here in Canada, actually. They published this thing and lobbied the WHO. And long story short, ultimately in February 2020, a decision was made not to include it in the very limited context that it was going to be included. And even though there's still some debate, is it a healthcare term? Is it not? What is it? So in that sense, it's a tempest in a teapot. And what's really interesting to me about this whole thing is why the effort. They are so afraid to give any legitimacy to what insightful judges are saying. You don't even have to bring any expert evidence. Would the courts take judicial notice of it? And yet they are so afraid that even an offhand reference to it in ICD 11 was throwing them into a tizzy and led to a whole worldwide thing and comments being posted. And basically, they created enough noise that the WHO said, you know, we don't need this. It's not really adding anything to our publication. It was just an example so that if some family doctor in a country that doesn't have a lot of knowledge of this came across the term and they went looking in their Bible for like, what is this? They'd at least see the reference. That's really all this was. And so the lesson is, if they're that worried, the denier community, that they would put this sort of effort in and their document, the collective objection document, it's about 200 pages long, is so filled with just stuff that is absolutely untenable, wrong, twisted, misleading, shameful. It exposes them for who they are. And the signatories to that document know who they are. And I would welcome a debate with any of them at any time.
Okay.
So no need to
I have
worry.
another question. That's
Yep,
like very
go
similar
ahead.
then. So that kind of brings me back. That was international, but that brings me back to the Canadian debate. So we have Canadian Equal Parenting Council that's put two bills together, and they both failed. And I think so. The question is that if like we have these same PA deniers here, like we do, and so how can the silent majority, because the majority of, according to polls of Canadians, like just the silent majority of us that are just like, you know, normal people, same family, same parents, we want shared parenting as a default. We don't want the drama after divorce. We don't want high conflict. We want our kids to see their extended family. So how does the silent majority overcome these shrill minority groups and lobby groups so that we can have equal shared parenting as a default after divorce and get these bills passed?
Okay, so we're making a little segue here from PA to shared parenting, and I've already indicated the link between the two.
Mm-hmm.
Shared parenting is a broader issue in that it will save way more kids from trauma. It will certainly go a long way toward saving the children involved in PA cases from some trauma, but it will
But I'm assuming that it'll greatly mitigate PA. Like
it certainly will decrease significantly the expected return on a PA campaign,
Yes.
but in and of itself, it is clearly not a sufficient answer to PA. So that it's important to bear that in mind. But it's a worthy topic and goal in and of itself. And so let me, in answer to your question, how do we get past the shrill minority?
Yes.
They come from two groups primarily.
Okay.
One is the domestic violence, extreme feminist community. And so there's a certain careful response there that is required. When I was presenting to the Senate, I was seated right beside and spoke immediately after someone who self-described themselves as a radical feminist, speaking on behalf of various groups. And it was just a nonstop attack on men as men, something that no man would ever contemplate saying about women as a group. It should have been cut off by the the chair of that day's proceedings, but they didn't, and they let it just go on and on and on. And then I come in, speaking about equal parenting, and the first thing I did is I made it clear that I'm here to talk about the 97 or 98 Sorry, somehow I got muted. Sorry, you're muted.
Yeah, sorry about that. I think I was trying to mute some other people that just came in. Sorry about that.
All right. So not certain when I got muted, but so the answer to the pushback on equal parenting from the domestic violence / feminist community is quite simple. We're talking about the 97% of cases where there are no allegations of domestic violence, or they're really weak and unsubstantiated in the first place. Number two, if the statutory provisions guiding courts to take domestic violence into account in whatever way is relevant coexisted peacefully for 30 years with the maximum contact principle in our Divorce Act, there's no reason it can't coexist peacefully with rebuttable presumption of equal parenting. It's just the maximum contact principle juiced up a bit. That's all. And so that's how you deflect the domestic violence concerns. In terms of the feminist community, whose argument seems to be that men are inherently abusive, you challenge their science, you point out that the legislation is gender neutral, that it's offensive to suggest otherwise, and that children don't distinguish. Children need, we know from science, to leave childhood with bonded relationships, with two primary relationships, not a primary relationship with one parent and a marginalized tangential issue like an uncle with their father. Secondly, increasingly with women in the workforce, do we want to disadvantage them? And so the PA denier community and the anti-equal shared parenting communities have no answer for my female clients. You'll hear some stuff saying, oh, we're not saying that it never exists, and we're just saying that it's very, very rare. And there they run headlong into Clawar and Rivlin and Jen Harmon and their work. And I once asked one of these zealots, well, what do you say to women going through it? And they said, well, we don't use the term. Instead, we use the term domestic violence by proxy. You're getting at the other parent through the children. But again, that's just semantics. The other thing to realize is in every PA case, women suffer because it may be the father being alienated, but there's a grandmother and there's an aunt and there's female cousins and there's the female children who are all getting traumatized. So in every PA case, women suffer, and the denier community should be ashamed of themselves for wrapping themselves in a false flag and ignoring the female victims of PA, which is a power dynamic, not a gender dynamic. And that's in part how you silence those voices. But how do we get shared parenting over the top? Easy. You push the science. And the International Council for Shared Parenting, which held their 2021 conference in Vancouver, Ed Kruk chaired it, had that was the 4th annual conference, and I'm on a couple of their committees. So we push the science. Secondly, we push the public opinion polls, because several decades worth of polling indicates broad acceptance of equal parenting across every demographic, age, region, political affiliation, and yes, gender. There is exceedingly strong support. And when I was in Ottawa, I was challenging them that their constituency are not these various special interest groups sending representatives to Ottawa. Canadian Bar Association was one, and misstated who they represent. So the Canadian Bar Association has somewhere between 30 and 40,000 lawyer members across the country. There are 2 groups, the family law group and the child protection group, which maybe between the 2 of them might have 3 or 4 Canadian Bar Association members, 3 or 4,000. But they come in there and say, we represent, whatever it was, 30 or 40,000 lawyers across the country. And the answer is, no, you don't. If you took a poll of real estate lawyers and tax lawyers and business lawyers and municipal planning lawyers, you'd find broad acceptance of equal parenting, because they're just normal people and they've had friends and family members go through the court system. So there's spin everywhere.
Yes, and I noticed that some of the comments from the Bar Association last time that they shut down the bill, they just repeated a bunch of rhetoric from the PA deniers, and so they are one of the groups that I would consider that are that are lobbying against shared parenting.
Well, they when I was before the House of Commons committee, I was sitting beside the 2 Canadian Bar Association representatives and followed their speech with an impassioned speech. And I got a lot of nodding heads from the committee. I convinced the conservative members of the House of Commons committee to move the amendment for equal parenting. But of course, they got outvoted by the Liberals. So it will come. It will come. We just need to keep pushing, keep lobbying, keep updating the polls, keep pushing the science, have public awareness campaigns. And there are now 2 states in the United States, for those of you following this issue, Kentucky and Arkansas, that have a rebuttable presumption of equal parenting. Everything's going well. Litigation rates are coming down. Interestingly, false allegation rates are coming down in Kentucky. And there's a somewhat modified version in Arizona that is so successful that judges are just routinely handing out equal parenting orders. In Quebec, where the social dialogue is a little bit different, and to some extent, women are a bit more progressive, it is not considered a slight for a mother to just agree to equal parenting. It's considered cool, modern, progressive to have equal parenting the way it is in some of the Scandinavian countries. And so there's a little bit less controversy in Quebec about this. But if you follow the jurisprudence, you can see the trends. That trends are moving in our direction. And as the case law builds, and as more and more jurisdictions move to a rebuttable presumption, that will continue to influence the court system here as a generation of judges retires and younger judges who either acted for fathers or had some personal experience themselves or who are up on the latest science are appointed, you'll see the dial move as well.
Okay,
So,
Brian.
yes.
So there are a lot of judges, for my next question, the judges, lawyers, psychologists that don't acknowledge PA, like right now. And so we've had, like, definitely in the group, in the PAC group, like there's a lot of complaints about finding service providers. Like, it seems that there's like a misinformation campaign to basically brainwash a lot of professionals, it seems like. And so how do we get, like, if there's a momentum, as you're saying, like in Quebec, and like if is the new generation of lawyers, but what can we do to get this mainstream understanding of the correct information to professionals on PA, or speed it up?
Okay, so those are quite disparate groups that you mentioned. So judges is a matter of finding out who sets the agenda for the judicial training institutes and making sure that PA aware professionals, lawyers, therapists, etc., get to present there. And that's always been very non-transparent to me. Who sets that agenda and how does one get on the list to present to the judiciary? So that's number one. But the other way to influence judges is to win cases. And then when you're in front of them, have a really thick jurisprudential background. And the more cases I win at the Court of Appeal, the more impact I have. And, you know, just like lawyers talk, judges talk. And so a judge, they share facta amongst each other. They talk about their decisions with each other. And so if you educate a judge even through the one case you're in front of them about, well, that's the gift that then keeps giving, because in their interactions with their colleagues, they'll say, no, you know, I used to think that way, but I saw Ludmer on a case and he's convinced me of X and Y. You really should read this factor. Okay. And you know, there you have it. Judges do not like to be overturned on appeal. So if we have a real good, solid record at the appellate level, it carries a lot of weight. So that's your judges group. Lawyers, there's continuing legal education all the time. There's continuing desire to learn all the time. Lawyers who would go so far as to say, you know, PA is junk science, don't deserve to be practicing in this community. They should go do real estate law then, okay? Because they're certainly not up on the science or the law. And the mental health community is kind of interesting because, and I speak here with knowledge of my daughter, who's a clinical psychologist, what her training was, and she was highly attuned to these sorts of issues. And we had discussions as she went through undergraduate, graduate, and master's program and PhD on the training syllabus. And it turns out that in psychology, the focus is all on individual pathologies, as one would expect. And they really don't get a lot of training in relational dynamics, not much at all. So it's quite common to find psychologists who don't have the first clue about how to deal with a fractured family system and its complex
That's
dynamics.
surprising because the family is so important for development for children. Like
Correct.
It'd be fundamental for mental health.
Correct. But it's like you can't learn everything in school. That would be something you get continuing education, you get experiential training, you shadow another psychologist who has developed expertise in a difficult dynamic like that. I mean, we certainly didn't learn everything we needed in law school, I can tell you that. So if you're a professional, it's lifelong learning. And there's all kinds of post-grad type courses you can take to further your knowledge. And if you're interested in a certain community, then you really need to spend the time, take the courses, shadow the experts, buy the textbooks, read them to learn this very difficult area. So I could extend what I just said to psychiatrists and social workers as well. Social workers get a taste of this, but they're generally not as trained up as a psychologist or a psychiatrist is. But there is one professional designation where it's all about relational dynamics. And this is something that often people from one of the mainstream mental health disciplines go and do the courses to get the designation afterward. It's called LMFT, Licensed Marriage and Family Therapist. There's an American organization that I believe has the trademark so that they can give out that designation. There's a
Can you say it again? Licensed
marriage and family therapist. And I first got exposure to that community through an esteemed colleague of mine in New York, Linda Gottlieb. Her training involved, she was directly trained by Salvador Minuchin, who was one of the leading psychologists in the 70s behind the whole concept of family systems. And so if you just go to the websites, either the American Association or the Canadian, look at their training syllabuses, and then they all have lists of members. You will generally find people familiar with these issues, and then the specific application of their training to a high conflict separation and pathological alliances being set up in the family, you just have to ask. They'll certainly have the foundational training. Whether they have the experiential training, you'll have to ask. It may vary by person, but that's a good place to start. Okay. And then those of us who practice a lot in this area, we learn very quickly which therapists, which assessors, which parental coordinators, etc., really understand, and then we trade those names around.
Okay, so I promised that I would give some time to the audience today to ask you some questions. Can you, just for the next 5 minutes, can you talk about parenting coordinators? Because I think that's like a service. So a lot of the questions like we talked about, I asked you about psychologists and stuff. So most of them are not like able to like spend time looking into training or anything like that, because they're just parents trying to get by. And so they're looking for service providers. So a parenting coordinator, can you explain what that is? Is that a judge or like, and how can that help these parents?
Okay. Parenting coordinator is not a licensed activity. There's no supervisory college or anything like that. It's a service set, and it requires a settled parenting plan. So you need a court order prescribing the children's time with both parents. And what parental coordinators do is they work with the parents. There's kind of a standard form contract that's been developed by that community over the years, and everybody uses variations of it. And the goal of parental coordination is to assist the parents in getting along and managing the children within the context of their existing parenting plan.
And so who does this work as a parenting coordinator? Like who would that be?
You could come from any of the disciplines we've talked about, or a psychoanalyst, or a mediator, things of that sort.
Could it be a lawyer then?
Yes, could be a lawyer as well.
Could it be a judge?
Well, we don't really allow sitting judges.
Okay, so it could be like
To
a
also-
psychologist or the family therapist that you mentioned.
Yeah,
could do that?
exactly. Yeah.
Okay, and is it usually a paid service, I suppose?
Yes, it is.
And is it like, I guess that's a lot of people find it helpful because I've been hearing about it, and so that might be a solution going forward.
I would recommend a parenting coordinator in most families going through this.
Yeah,
There has to be a settled parenting plan, though, as the frame of reference. Because if there isn't, then the parenting coordinator is really
Can't
lacking a lot
anything.
of the powers that they need.
Okay, so I'm just gonna open this up to the floor now. I think Tyler was first. Tyler, do you have a question? You can go unmute yourself. Still here? Oh, he dropped off. I think he dropped off. If you have a question, Jenny S., you're on the top. Do you want to, would you like to go ahead?
Yes, I would. Hi, I'm in Minnesota. I'm wondering if you have any experience with grandparents doing this. Specifically, my father is, they have temporary custody of my little girl right now, and I can't even, like, I didn't even know what this was until it started happening, and I can't find anybody to kind of help me, or any attorneys that are even like willing to acknowledge it.
Yes, I've had several files where the grandparents are gatekeeping or marginalizing their own child and keeping the grandchild from their own child. It's effectively the same sort of case, has its own complexities, but ultimately at the end of the day, the system should, so long as you shine the parent up and deal with whatever the concerns are that led to the situation in the first place, the system errs in favor of the parent over grandparents. So in that sense, you're also a little bit better placed than in a parent-to-parent battle. It all depends on the particular facts that led to the situation, but it's common enough what you're facing.
Do you have any advice on how I can find an attorney that will kind of be on my side? It seems like it's more, Minnesota's kind of leaning more like against the mother, if you know what I'm saying. Like, I cannot find a mother's rights group or help or anything. I can't even get a good lawyer.
Okay, I do know a really good advocate in Minnesota. Jenny, if you would just send me your email, I'll correspond with you privately and pass her name on.
Thank you.
Okay, Alice, do you want to go next? Alice?
Hi, can you hear me?
Yes, I can hear you.
First, a big shout out to Monique and Carlo. Carlo was actually part of a father's rights group for equal parenting group in Edmonton when I first started going through my trauma as an alienated mother. So I would like to say hi to him because he was really helpful early on. I can't say I've had much success in my case, although I've maintained some relationship with my children. I haven't got to be the mother I wanted to be, but I've been the mother I could be in the circumstances. That said, I really question if in my case, or maybe another parent's case, I have a therapist that has been seeing my children since 2014, court-ordered on the request of the father. We are now 2021 and my kids continue to see the therapist. So I think any logical person would conclude if children still need some kind of therapy after 6-7 years, that there's maybe something wrong with the parent the kid's living with, or there's something dreadfully wrong with the therapist. It is only logical to conclude that, you know, if you were going to see a doctor and you had an illness, the doctor after a certain time as a professional would recognize, I'm not contributing to the betterment of this situation. It's maybe time I wash my hands of this and move on to someone with better expertise. So in my case, I believe a lot of my alienation has been in part come from this therapy the children have had from a therapist that ought to have known. And I told very early on, you do not have the expertise to deal with what's going on here. And I gave them, you know, the information. Here's documentation from people that say a poor therapist can actually contribute to alienation. So what I want to do, so my youngest child is now 15 and my oldest just turned 18. She's on her way to university. My relationship with them is kind of on the phone. I've since moved to Toronto from Alberta to kind of have peace in my life because I'm from Ontario. What I would like to do is go after the counselor. I can't get back what I've lost. But one of the, I guess, gifts, or if I'm ever going to do advocacy for what parents go through, is to go after the professionals that ought to have known better and did not follow a strict code of ethics, because they are in the best position, especially a therapist, to go, wait, something's wrong here, and I should have reported it, or I should have become more involved. So that's my comment, and I appreciate your thoughts on that.
Okay.
Thanks,
So the first is that one of the most common failings of the therapeutic community, you have to appreciate the mindset, right? These are people drawn to that line of work because they believe passionately they can solve these problems. And so there are times where they lose their objectivity. They're in a little bit too deep, and they refuse to let go and say that, sorry, can we have everybody on mute, please? Thanks. So no therapeutic process should last 6-7 years. There has to be a strategic plan for any therapeutic intervention in a family. Goals, what is the definition of success? What are the milestones? And at what point do we have to look at other types of interventions, because the traditional talk therapy, trying to get everybody to just play right, isn't working. And that's a very common failing. They just wing it, and you're just in this cycle where it's like an annuity, and they're getting the family in every 2 weeks, and you're talking about the same stuff over and over again. There's no measurable progress. Just, it fails because there isn't a strategic therapeutic plan.
In my case, very, very early on, because one of the, you know, I'm very aware of Edward Crook's publications, you know, as an alienated parent. I've researched everything. I didn't have the resources. Actually, one of the lawyers I did have ended up disbarred in Calgary. So kind of every angle I tried to get help, I just wasn't getting help. So the only help I could get was do my own research and read Edward Crook's book, talk to other parents that have gone through this. How do I do this? And, you know, I did psychology 101 in university, where these are the stages my kids are going through. How would I respond if I was them? Just I guess being really thoughtful about how I reacted or responded with my children. So like I said, I've maintained an auntie kind of role. I haven't been their mother. So, but it's the counselor very, very early on had aligned with the other parent. Very, very early on, I did exactly what you said. I sent letters to the counselor and said, if you're going to continue to see my children, we need to know where we're going with this. Like there needs to be measurables. How are we going to know in a year from now if there is some success? And they just kept saying, this is therapy, it's ongoing. And I'm thinking, so as of today, because I just recently got the billing because I'm very, very serious about looking to file a lawsuit. I think I'm in $20,000 in counseling with the same counselor over the last 7 years with my children. And there has to be, in my mind, and maybe there's not, maybe it's wishful thinking, some logical judge, some logical lawyer out there that says, what happened here is not okay. And if we don't make this become a message to professionals to bow out when they are aware or should be aware that they are kind of assisting in the alienation, that they need to bow out. And I feel like I can't get that message across. If there's going to be anything I do that comes out of this, it would be going after the professionals that should have known better and didn't do anything.
All right. So Alice, I want to make sure there's time for everybody else. If you would send me your email afterward, I'm going to send you a fantastic article by Dr. Jonathan Gould, who's a leading practitioner in these areas, called Is the Child's Therapist Part of the Problem? And that may prove helpful to you, okay?
Thank you so much. I will do that. I appreciate it.
Actually, Brian, if you have a moment, can you type your email into the chat? And
Sure.
everybody can just message you there. And Rob, you're next. You're the next person in line, if you're still on. Hello? Is Rob on? Okay, we'll move on to, I think it is Sylph Nightbloom. Sylph, are you there? You have to unmute. If you're on mute, you have to unmute.
And there's one or
Can you
two
hear
people.
me?
Yeah, I can hear you.
Okay.
Hi.
Also, there's one or two people who are not muted. So would everybody make sure you're muted?
Yeah, if
please?
you're not talking, can you please mute? Thank you.
Hi. I have a Canadian daughter, and actually she's a dual citizen. I'm American. I live in Hawaii, and my daughter's currently living in Orangeville. I lost custody under fraudulent circumstances back in 2017, and temporarily that was. Our order came out in 2019. They've not been following the order. A lot of the behaviors are alienating. For instance, I'm not being given overnights, even though they're not precluded in the order, because the stepmom is telling my daughter that my current partner, my new spouse, would molest her, and saying that he's that kind of a person and I'm somebody that would just stand by and condone it. And there's no reason, absolutely nothing. Like, he's not a sex offender. They've never had any problems. He and my daughter get along really well. And she wants him along on visits. She wants to have overnights, and she's not being allowed to. I feel like that is definitely an alienating tactic that they're using. And also, while I'm away in Hawaii, I pay for a cell phone for my daughter, and she's supposed to only have it restricted during school times or obviously during sleep hours, but they keep it from her. They withhold it from her. She's 13, by the way. I've been paying for this phone for the past 2 years since the order came out, and it's in the order that I do pay for it and provide it so that she may contact me and my side of the family. And in 2 years, I've only had 11 phone calls with her because they make sure that it's never plugged in. And when she asks for it, they make her ask per use for permission, and they generally say no, so that they basically trained her out of asking. And not only that, but during our parenting time here in Ontario this summer, they have been constantly bombarding her on her phone with text messages and phone calls. They don't leave us alone. They've actually foreshortened part of the schedule that we had for my visitation of her. Just off the cuff said, well, you're going to have to bring her back an hour early, or you're going to have to pick her up an hour late. And they don't really give good reasons for it. They've texted her in the middle of our visits asking if she would like to come home early to hang out with friends. Like, it's just a constant bombardment that we have going on. And probably the icing on the cake of all of this is that the stepmom has called the state of Hawaii Child Support Enforcement Agency, because I'm not able to pay the full amount of child support that's been assessed on me, especially during COVID. I'm self-employed and I'm disabled, so I get a monthly disability check. I put all this into the court, but basically the stepmom is trying to get my driver's license and passport revoked because I'm only paying $100 a month in child support. So that feels extremely alienating. So cut to the chase, my question is, do you think that there is any wisdom in my trying to get a custody reversal when I live all the way in Hawaii? Everybody's saying a judge will never reverse custody because you're not Canadian and you live in Hawaii. Is that true?
As a sweeping generalization, no, that's not true. However, reversal of custody and placement with the other parent, which I've gotten many times, and which is at times the only remedy that's going to work, is kind of viewed as a remedy of the last resort, and that the first step would be a compliance motion to deal with all of the ills in the family system that you've mentioned. There are ready remedies legally for every single one of those. In a compliance motion, you can ask for restraining orders against the stepmother for what she's doing. You could sue her for defamation. You could consider criminal harassment charges, but I generally, that's the atom bomb remedy. I would never start there. I'd start with civil harassment and restraining order type relief. But that's what you have to do. And the complexity of your being behind on court-ordered child support is something you'll have to contemplate, because they'll put that up as a defense seeking to deny you a forum. So you'll probably have to bring a motion to vary support in the short term in conjunction with the compliance motion. And courts do have the ability to deal with urgent child-related matters, and yours certainly seems to be one, notwithstanding arrears of support. But you can't just be cavalier about it. If there's legitimate reason for a reduction in your support obligation, then you need to bring a motion to vary the support, and you can vary it retroactively.
I didn't know that I could vary it retroactively, but
Yes.
It's already in my filing. I filed a motion to change. I didn't know about a motion for compliance. Is that a different form from a motion to change?
A motion for compliance is a motion on Form 14. So it's not a new case in and of itself. It's either something you do to enforce a final order or to seek interim relief within a case that it seems you've already started.
Okay, what I feel like is happening is that our order is not very specific. It's pretty vague. It just says that we shall share equal parenting time and that it's as to be agreed upon by my daughter, my ex, and myself. It doesn't make a mention of the stepmother in there whatsoever, but she's the one that's basically calling the shots with all of this.
So
but she is a party to the case.
Okay, so all of this needs to be tackled broadly, and hence it's good that you brought a motion to change, because you need a different order. Also, with you in Hawaii, I don't know how equal parenting is going to work, but
right.
Okay, but so you need a new case, and you started a new case, but you should also bring a compliance motion within the new case. and get
Okay.
your relief there as soon as possible.
Okay, that all
Okay.
sounds really good. Thank you. Thank you very much.
My pleasure.
Thank you. If you're not speaking, can you go on mute, please, everyone? And Moody, you're the next fellow in line. You can unmute yourself.
Hello, hi, yes, thank you so much. So I live in Ottawa, Ontario here, and got separated about a year ago. For the first 6 months, we did voluntary 50-50 with the children, 2 girls, 10 and 13. And then we had a dispute over New Year's Eve, and my ex just basically said, okay, well, we can't agree on that day, so you won't see them again. And I basically kept them from me since New Year's Eve. Filed an emergency motion, and she basically fabricated some texts and FaceTime and said, oh, no, they communicate through FaceTime and text, so they're good. They don't need an emergency motion. It didn't meet that threshold. And anyways, we did get them agreed to a parenting assessment, and a meeting with the parenting assessment, who I think is a social worker, in a week or two. And I was just wondering if you have any advice on, what to lay out for the person doing a parenting assessment when I haven't seen my kids now for 8.5 months, and I'm pretty sure they're brainwashed to fear of saying yes, I do want to be with dad equally.
Okay, so what you're going to do is you're going to do a brief on the family history, on the prior relationship with the kids. It's very meaningful that the other side agreed voluntarily to equal parenting. And you're going to try and describe in detail what happened since, and the unreliability of anything the children would say at the present time. You're going to get as many collateral statements from people to be interviewed as possible in writing, and with their contact information for the assessor to speak to, friends, family members, others who have seen you with the children over the years. You're going to have to anticipate all the mud that the other side is going to throw and give the assessor a written response to all of that. And I'm sure you've got pictures. They're probably not going to sit through video, but pictures, cards, everything to show the deep bond, love, and affection. And again, it's very meaningful that the other side voluntarily agreed to equal parenting. It's going to be very hard for them to explain
What happened
and
then?
justify what happened since. You'd need some sort of completely out of character, explosive series of incidents, and they will have their theory of the case. And you have to try and anticipate what that is, and then ensure, because a lot of assessments are not well handled on this point I'm about to make, ensure that you get to respond to all of the mud they're going to throw within the assessment process to justify the very extreme position they have taken. And very, very often people get assessment reports back and it says, mom or dad said this or that about the other parent. And the other parent is saying, well, I've got a good response to that, but the assessor never asked me about it. So why is that accusation even in the report? It makes it sound like it's credible, or even though all it says is mom or dad accused the other parent of X, you don't know, why is it there? Unless the assessor is putting some weight on it. But usually it's supposed to be, and the other parent's response was X and Y. So these are just common problems. As you go through the assessment process, you document everything that they are told, and you follow up with a letter. So this is something I taught myself when I went through a custody and access assessment in my own case. I'd have a meeting, various things would be discussed, I would make various points, the professional would probe on a couple of things, and I would I would see where the other side is coming, maneuvering, and I give an answer. And meanwhile, you look across the table and all you can see is somebody writing sometimes, not writing other times. You have no idea what they're writing. All you know is that you're speaking a hell of a lot faster, unless they're a master of Pittman shorthand. They're not writing down everything you're saying. So after every meeting, every interaction, every phone call with the assessor, they get a letter from you. Thank you for your time yesterday. I'm writing to summarize our discussion so that I can make sure that we each know what we discussed and what the next steps are. I raised this issue that happened recently. You agreed with me that is very bad behavior on the other parent's part, et cetera, et cetera. Now, that serves multiple purposes. Number one, you control the assessor's file instead of the assessor controlling the assessor's file, because they can't ignore what you've sent them in writing. If they do, it's to their peril. Secondly, people don't realize how many files, your assessor might also have a thriving therapeutic practice that involves in advocacy, and then there's a vacation or two thrown in, and then they write a report 6 to 8 months after they started the process. And they look back at their notes from some meeting that they had with you 1 month into the process, and they struggle to read their own handwriting. They've long since lost any memory of anything you told them that for whatever reason they didn't write down. And of course, then you get work that really leaves a lot to be desired in the finished product. But if you have followed up every meeting with a detailed letter, and I understand my ex must have raised this issue because you raised it with me, and I gave you the following answer, and I've had further time to think about it, and the following additional responses occurred to me that I want you to consider, X and Y. So when they go back 5, 6, 7 months later to write their report, they will read your letters then, and they will be highly influential. So I could do hours on how to do well in an
Got another couple
assessment.
other questions too, Brian.
Right, but all I'm saying is those are some of the high level points for people going through an assessment. There are
Would you
also
recommend-
examples of why assessments often come out wrong.
Would you recommend like a briefing binder to give her sort of the history so that she doesn't like?
That's
Yeah,
exactly what I was saying.
Yeah.
A briefing binder with your history, collateral statements, pictures,
Yeah.
chapters on particular issues, chapters per each child, things
Yeah.
of that sort. Okay.
Thank you. Thank you so much.
I have Heather's question here. She can't come off mute, but she says she wants to ask you about the upcoming bill C-247, an act to amend the criminal code controlling or coercive conduct. And I guess she just wants to ask you about that, or if you can comment on that.
Okay, so we first saw this in the amendments to the UK criminal law, goes back to, I think, 2015. And I was looking at it at, it's shocking the breadth of just a couple not getting along that is suddenly being criminalized. So when you look at the definitions of coercive control as it's now found even in our Federal Divorce Act, financial coercive control. So one parent is the more prudent of the two, would like to keep the family on a budget, would like to be saving for retirement, and is the one who has to frequently say, no, our flat panel TV is 3 years old, it's fine. We don't need the latest one, things of that sort, okay? Well, there are some who would say that's financial coercive control. You're controlling the other spouse. You're denying them their freedom. That's how concerning this is. On the other hand, when you read through the definition of domestic violence and coercive control in the updated family law legislation, it fits PA like a T. Remember, I spoke before about domestic violence by proxy. And again, my good friend Jen Harmon has a peer-reviewed journal article out equating PA with domestic violence and child abuse. So there's a lot in this concept that can be useful to this community. The extension of certain unhealthy, trying to use very general terms deliberately, very unhealthy couple dynamics into the criminal realm, I personally think is a real problem, in that it's really a rough tool, criminal law, not very subtle, and there are situations that should be diverted to therapeutic and counseling, or just this couple isn't made for each other, they need to separate, and instead you're criminalizing chronic behavior. That's my concern, is a bit of an overreach there. I certainly accept it within the concept of what family law legislation deals with. And as I say, there's some good tools there for people in a PA case.
Okay, Marcella, do you want to go next?
Yes, thank you, Monique. Hi, Brian. How are you
Hi.
doing this evening? So you are a little familiar with my judicial ruling. We've spoken on more than one occasion in the last few months. And in the last conversation we had with the motion that is just about to be filed in the next week or two, you had suggested or advised covenant parenting. And I did a little bit of research on that, but I'm seeking a little bit more clarification. If you can give us a brief synopsis and a little bit more information on what that is, I'd appreciate it.
Great. I'm glad you raised that. So one of the best tools I've come up with over the years is what I call a covenant pattern. So a series of rules for parents, some of which are what we call positive covenants. You shall do the following, and some of which are negative covenants. The following matters are prohibited. And that language comes from my business law world, where in a loan agreement or other long-term contract, you have covenant patterns. Positive covenants, keep your working capital ratio above X. Negative covenants, you're not allowed to pledge your assets to any other lender. So it translated beautifully to family law, where what I was seeing in court orders was simply speak well clauses. You know, don't say anything negative about the other parent in front of the children. But we knew it was always going on. It's observed in the breach. And unless you put a webcam in the other parent's home, or the child is ratting out the parent who's not behaving, how are you going to prove that? And what came to me is we need a constitution for the family that puts even more emphasis on forcing positive supportive behavior than simply prohibiting negative behavior that's hard to prove. And so my standard covenant pattern goes on for about 5 pages. Initially, I was getting a lot of resistance from the judiciary. Oh, Mr. Ludmer, we don't do this. And then it started to gain traction. And then certain cases started to come out that said in high conflict families, we need to be very detailed, very prescriptive, very broad in our rules for the family. And that plays into the parental coordination that we were talking about before. The more you have in your court order, the more tools the parental coordinator has. And if anybody's interested, email me and I'll send you a copy of my covenant pattern. We customize it in each case. We take all my standard stuff and then we add to it because every family has some unique nonsense that's going on. And the most recent conceptual addition to what I've had developed over the years is what I call prohibited narratives. So every conflictual family system has these elephant in the room false narratives. She left us at Christmas. No, she left you, sir. She didn't leave the children, and phrasing it that way is a pathological alliance. Dad is mentally deranged. No, he's not. On and on. And yet you could even have a court recognize that a statement is untrue, and yet it repeats. It's ingrained into the fabric of the family dialogue. And so I started to interview these families and pull out all these false narratives, come up with a list of 10 or 15 things that are standing in the way of progress on the real issues and prohibit them. True or not, exaggerated or not, used to be true but not true today, or even if it's still true today, I don't want to hear it because it is creating problems and interfering with peaceful coexistence. If the Children's Aid Society is not prohibiting a particular parent from having contact, then I really don't care about your narrative. There's this, there's that, there's this, there's that. Just suck it up and move on and just accept the other parent. They're, by definition, a normal, capable parent. It's not to say we won't do courses, read books, try and shine up our parent clients all the time. But these false narratives are toxic. And so the covenant pattern has a place where we will put a customized list of prohibited false narratives in a particular family. And so that, Marcella, is a parental covenant pattern. It's a term that I invented from business law to describe a group of to-dos and stuff that's prohibited that will lead to family peace and harmony.
Fantastic, Mr. Ludmer. Thank you so much.
Tyler, I think I saw you online. Do you want to ask your question now? If you come off mute. I can ask his question for him. He's got it in the chat, or are you? I don't
Sure.
know. Can you ask Brian about legal procedures that a parent must follow when contact is denied, when a custody order is in place, and when a custody order is not in place? So in both those situations.
Okay. If a custody order is in place, it's a compliance motion. In Ontario, it's brought under Rule 1 sub 8 of the family law rules, and you're seeking the court's assistance in enforcing one of its own orders. And that gives you the opportunity to not just get the court's assistance in enforcement, but also to get a parenting covenant pattern put in place, get makeup parenting time ordered, and various other bells and whistles that will prevent the issue from repeating again in future. If there is no court order in place and somebody is exercising self-help, you go to court seeking an initial parenting order and a 50-50 one at that point, since the other parent, by gatekeeping and exercising self-help, contrary to the prevailing statute, which doesn't give them the right to do so, is proving that they're not the, quote, friendly parent, quote, as prescribed in our family law legislation. So either way, you're going to court. Either way, there is a remedy available.
Great, thank you so much. Judy, did you have a question? If you go on, if you take yourself off mute,
Yeah, can you hear me?
I can hear
Yes.
you. Yep.
Okay. Hi, Brian.
Hi.
We actually emailed a little bit this morning. I wanted to thank you for allowing me to reach out to you in a few days. I don't want to take up too much of your time, but the question I have sort of piggybacks on your last answer. My situation, I was taken to court. They wanted full custody, my ex and his new wife. We had medical issues in place and we didn't have any communication between the two of us, or at least communication that was helpful towards the situation and the children. I had initiated a 6-month contract with Children's Aid because I had a lot of false allegations. So I invited them in my home for 6 months. I also was able to apply for and receive a lawyer from the Office of the Children's Lawyer at that time. At that time, my children were approximately 5 and 8, and it was a 3 to 4 year battle. Long story short, the Office of the Children's Lawyer recommended full custody to me. I was still terrified to lose my children because we were still in negotiation. Once I agreed to sign off on a lot of financial situations, such as no 7-section expenses, very little for daycare expenses. When I agreed to those demands, he signed over custody. Now we have children that are 14 and 17. Had an argument with a 17-year-old. 2 days later, all hell is broke loose. You and I will discuss this more, but I guess my question is, at 17 and 14, can the court reinstate, or at least, sorry, I'm struggling for the word, enforce the court order? I was awarded full custody and now I've been completely erased from the entire situation.
Okay.
Is it worth proceeding,
All right.
fighting at that?
Those are
at that
two completely different questions. So one,
age? Okay.
can a court do it? Answer, yes. Court orders in the normal case for parenting time last until a child's 18. And if a child is, disabled in some sense, they may remain a child of the marriage and amenable to court orders for many years thereafter. Or even perpetually, for example, if they're highly autistic or have other challenges and will never truly become independent, okay? The second question is it worth it? And there are various aspects to that. So what's it going to cost? How fierce is the opposition going to be? If the 17-year-old, by the time you get this ruling, is going to be 17 and a half, and there's nothing special about the child, so the child's going to age out at age 18, then you probably have your answer there. But certainly the 14-year-old is a completely different story, is only beginning their journey. And you should definitely fight for the 14-year-old. I will tell you, however, that I was successful on a motion 2 years ago, very hard fought, with a 16-and-a-half-year-old. And secondly, what we know from today's neuroscience and the teen brain is that the teen brain doesn't fully mature till 24 and a half, and that's where the last and most important piece falls into place. The prefrontal cortex and all the executive functioning. And isn't it interesting that 100 years of insurance company driving statistics substantiate that at age 25, drivers suddenly become one category safer, and you see insurance rates for young adults drop at age 25. Okay, so I've always found that interesting. But our court system, so far in my experience, while there's passing understanding of that, needs a lot more education there. So the argument that in contact refusal cases I've gotten a lot of traction with, instead of the purely neuroscience response, has been, it is the job, Your Honor, of all the adults involved with this family, the parents, court services, therapists, assessors, etc., to ensure that the children come out of childhood while the court system has some influence on this situation, with bonded relationships with both parents. It's a failure of duty to the children to just give up and say, oh, well, because you only get one chance. And as anybody who has raised a young adult knows, kids get very, very busy from ages 18 and up. Many of them go out of town to university, as my kids did, or they're busy with their friends, their activities, and your time with them is, 15 minutes here and a half hour there. So we use the social capital that we've developed when our kids are younger. And so it's extremely important to come out of childhood with a deep reserve, a really bonded relationship with both parents. And the social science literature on what lies ahead for children who don't is enough to scare anybody. And I use that in my cases as well, both PA cases and contact refusal cases. So those are all arguments available to you, Judy. And, some people will say, like, I don't care, she's 17, I will fight as long as I can because I'm demonstrating my unconditional love in that regard. So I have the case law for you on older children that courts still need to do their stuff, and that's what you'll deploy. Okay? All right, next question.
Carlo, you're next. You come off mute.
Oh, hi. Hi, Brian. Thank you very
Hi,
much
Carlo.
for the good insights. My question is with regards to the next step. I actually have been in equal parenting since 2011, so 10 years now, but I believe that equal parenting can be gained. So in my case, what happened was my children are 3 kids, 3 girls, 14, 16, and one just turned 18. But I had them since my youngest was 4, being a 50-50 parenting. But what happened is, like, my ex refamilied, so she had 2 more kids. She didn't work, so the income and the child support payment the burden was on me because she had 0 income, and I guess the maintenance recalculation doesn't impute much, so that was to her advantage. Also, I do not think that the kids were getting like the worthwhile experience for the equal parenting itself. Like, they live in the basement, she was on another family on the upstairs, and I guess the kids were not thriving at all. So I was just wondering if there's any steps to avoid gaming the equal parenting system if once that ever happens.
Okay. Remember that those of us who are advocates for equal parenting, our actual construct is a rebuttable presumption of equal parenting. So it is presumed, generally, all other things being equal, that equal parenting produces the best outcomes of children of divorce. It's the next best thing to having a fully intact family. But it's that rebuttable presumption part. So when I'm asked, for example, when I'm advocating in Ottawa, I don't wait for them to challenge me. I state right out, we are not saying that equal parenting is for everybody. If dad is an investment banker and he gets these 3 months assignments out of town, it's not going to work. If mom works crazy shift work that it's almost impossible to build an equal parenting schedule around, it's probably not going to work. If one parent has a substance abuse or alcohol problem, it's probably not going to work. But for the vast, vast majority of families, it's the perfect answer. We don't want to fund or make easy the battle for I want to be the principal parent. Okay, in your case, Carlo, if one parent, because of multiple commitments, is not able to take proper care of the children, well, then that might be the type of information that a court would say, okay, that is relevant, and maybe equal parenting is not the most appropriate parenting plan for these children. Okay, so on the other hand, we want to be careful not to pathologize poorer families. So, comparing the lifestyle children have in the two homes and then saying, oh, well, why would we deny them? Like, they could live in a 5,000 square foot home. So you have to be careful. These things are complex. But I basically answered your question by saying, if you put together a meaningful case that some other parenting plan is more appropriate, will better meet the needs of the children. And there's the trick, because if all your ex can afford is the basement portion of the home for these kids, that'll be the case whether she has the kids half the time, 45% of the time, 40% of the time, 35% of the time. So the parenting schedule, monkeying around with that, may not be the answer. You may need something more specific or granular, like the basement as it's currently configured doesn't do the trick. Only 2 of the 3 kids can be down there because there's not enough room, and you're going to have to find a bedroom for one of the other kids upstairs. Or maybe it shouldn't be the case that your kids are in the basement, the other kids should be in the basement, but of course the other kids are there 100% of the time or whatever. So I can't generalize. That's the whole point of the rebuttable presumption.
Right.
Okay. That it ultimately does come down to the specifics of a particular case, but within a frame of reference that the rebuttable presumption creates.
Right. And I probably want to add to that as well. Like, say in taxation, only one parent can I guess, declare the kids as as their dependent.
Right. But there is an answer to that in equal parent. We alternate year by year. CRA will deny both parents. It's a problem in our tax laws. CRA will deny both parents the child care deduction
if the parent doesn't cooperate.
If they don't coordinate their tax filings. And so you have to coordinate the tax filings. We usually do it by sharing alternating years.
Yeah, so that's an example for me, because that is used as a weapon. She doesn't work, so zero income. Actually, from what I heard from her new family, she's actually.
Carlo, we're going to move on to the next person, okay?
Okay.
Ruth, do you want to go on?
Yeah, hi there. Hi, thanks. Yeah, I'm in Toronto as well. So this has been ongoing for a couple of years now. So, I mean, I could be here all night giving you details and stories and whatnot, but my question is, at what point might it be necessary and how difficult would it be to remove a 13-year-old girl from an alienating father for the appropriate treatment? What's needed? And how extreme a situation, because it's a very extreme situation. Where do we have to be? At what point do you make that call? It's hard. I know you don't know, obviously.
Where all other interventions have tried and failed.
Yeah.
that's where we resort to removing a child from a source of emotional harm.
Okay.
So you try a compliance motion first. You try and get parenting covenants. You try and enforce the parenting covenants. You get an experienced family therapist who can enforce in practice
Yeah.
the parenting covenants you put in place. And if
yeah.
none of that works,
Mhm.
then what's left? The child continues to suffer from whatever you would write up that the child is suffering and not doing well in socially, in school, this, that, this, because of the loyalty bind. And you relate it to your requested remedy.
Mhm.
It might require some advice to the court from the therapist. It might require some advice to the court from a custody assessor. It really depends on the circumstances, or it may simply be a matter of convincing the court, take a look at your palette of options here.
Mhm.
Everything has been tried and failed. And clearly there's trauma going on. And, so you need a solution to the trauma.
Okay.
Okay?
Yeah. Yeah. It's, I mean, just quickly in closing, it's, there's no way when you have a joint custody, when someone, all they have to say is no. They just say no to an appropriate therapist, so 2 years later, we've,
Okay.
right? Like, what do
Right.
you?
Well, I can tell you what you do there, Ruth.
Yeah.
Even in cases of joint custody, or
Yes.
as we now call it under the statute,
Yes.
joint decision making,
Mhm.
if there's paralysis or somebody feels that decisions are not being made in the best interest of a child, even if you don't have decision making authority,
Yeah.
the court can overrule it.
Yes.
So if someone has medical decision making authority and is not exercising it properly, yeah, a court will substitute its judgment for that parent. Doesn't do so easily, but the types of things that someone is going to take to court on the basis of poor or just obstructionist decision making are usually pretty compelling.
Yes, that's true.
So,
And yes, and that's where we are now. We have a very
all
good, yeah, okay.
So a court will order therapy over the objection of a parent. They do so all the time.
I know. Okay.
Okay.
Okay, thank you. Yeah, thanks you very much.
Karen, B, do you want to go next?
Yes, thank you very much. Thank you for this, Brian. So my question is, I would like to request a review of my case. During the trial, my ex admitted to committing tax fraud for over 10 years. It's my understanding that this means that the previous applications filed pertaining to financial disclosures would actually be fraud and perjury. There are a number of other areas where the law has been broken inside of the case. And what is the process of filing is it a judicial review or a review of my case to have it considered for the areas where it has not been upheld and that there have been unlawful knowingly filing perjured and supporting perjury in the case?
Okay. Karen, where are you located?
I'm in Alberta.
You're in Alberta. Okay. So I'm going to speak in the language of Ontario's rules of civil procedure, because obviously that's what I'm familiar with. But
Yes.
Every jurisdiction has the same thing. So were you in Ontario, I would say no problem. You're going to bring a motion under Rule 25, court orders procured by mistake or fraud, and provide the evidence seeking to have the previous matter reopened because of these revelations. And
Sorry, would you just repeat that again? Sorry, motion under Rule 25.
right, that's the references to the Ontario family law rules,
Yes.
to have your case, it's really the order resulting from the case, amended to reflect a correction for the fraudulent or erroneous or mistaken data under which it was issued.
Okay.
Okay.
Okay. And if there's been several of them?
Well, you might be able to bundle that all in one proceeding. You might
Yes.
bring a procedural motion first to bring the issue to the court's attention and seek advice. Like, I'm seeking to overturn this trial and this motion, and
Okay.
just want procedural advice as to how the court system wants to deal with my requested adjudication. And here's not all my evidence, but the best of the best evidence to show you that I'm not just speculating here. I've got solid revelations,
Yes.
objectively provable.
Yes.
And then the court will help you structure it. Every court system has a procedural rule for just this very purpose.
Really?
Yeah.
Thank you. That is so good to hear. Thank you
Okay.
very much.
Brian, thank you so much for what you've done for us today. I appreciate you donating your time, and what we really love about you is your empathy. And thank you so much for caring about my parents here on my page. And I hope you'll come and speak to us again sometime.
Oh, my pleasure.
You're always welcome with us here, and we love you.
Okay. Thank you so
Okay.
much.
Yes, I'm just going to share my screen. I'm just going to go over the Facebook page one more time here. So we have the Facebook group, the Parental Alienation Canada. That's who hosted the chat today. We have a great group going on here, great people. The parents support each other. We have common sense rules and engaged moderators. So if you want to come and join us here at our Parental Alienation group, it's open for parents and also the extended family, children that are formerly alienated, and service providers, or anyone that's interested in the issue. So thank you so much again. Brian, I really appreciate it. Like I said, I really appreciate you donating your time today.
Okay. Thank you very much. Good luck to everybody.
Take care.
Thank
Thanks,
you.
everyone.
Good night.